All persons having anything to do before the Honorable, the Judges of Court of Appeals, draw near and give your attendance. For the court is now in session, God save the people of South Carolina and this court.
Please be seated. Good morning. It's good to see both of y'all.
Thank you.
This feels weird because this is my chief to my left, but he is now in serving.
I'm in relaxation status,
So,
using my mind.
Until we can elect a replacement, but hopefully he'll even stay after that. So I'm told I have to sit in the middle, even though it feels more normal for him to be in the middle. And then we have Judge Vincent as well. So we are happy to have y'all here today.
But I've been acknowledged to be the best knocker in the court.
He is the best knocker. Taught me how to knock on the door.
I jumped.
He wants you to. That's intended.
I wasn't paying attention, I jumped, so there you go.
And I didn't even use the thing, I just used my head.
Some days call for that. Madam Clerk, if you would call our case.
You are on a case number 2020-000-757, Doretta McHugh versus John Doe.
All right. Yes, sir.
May it please the court,
Good to see you.
Daniel Bowles here for appellant. I forget if I'm supposed to activate the clock. Are y'all?
It's already going.
It's going. Okay, thank you. Your Honors, I'd like to start with a quote from the defense in the opening argument of this case, and then I'm going to go into the facts and the reason that we've appealed, and then the harm that I think that the objectionable material brought to our case. So the quote is this, and this is from page 81 of the trial transcript, starting on line 20. The respondent argues to the jury, "You're going to find out that just 6 weeks before this accident," which is the one the trial was about, "he, the appellant, was training to learn how to drive a motorcycle. He did something wrong and flipped over the handlebars and hit his head, just like this accident." Now, this case that we had the trial about was also a motorcycle collision.
Did anybody object during opening?
No, ma'am, not to that part. The case that we were there about, the trial, was a subsequent motorcycle wreck. My client, the appellant, was riding to work and was making a right-hand turn into a gas station when a car came up behind him and hit him, knocking him off his bike. He hits his head. By the time trial took place, he had died in an unrelated drunk driving collision. A drunk driver pulled in front of him and killed him. So at the trial, he could not testify. We had to offer.
Was the last fatal accident, sad accident, was it a motorcycle accident also? Was he on a motorcycle?
That's correct.
Let me ask you, you're concerned about the other accident that occurred before the one in question here today. That would have gone maybe, because he had extensive medical bills as a result of this accident, did he not?
He had some. I would not characterize them as extensive. I think that the bills were in the $1,000 range or something like that. And I think that the excerpt, which we'll get to, was, I understand that it would be proper for the defense to say, prior to the collision that the trial is about, the plaintiff and appellant complained of headaches, had fallen and hit his head. The problem is that they took it a step further and they said, because he fell off his motorcycle before, just like what he's complaining of in this collision. And they were using it as support for a comparative negligence argument, trying to say that the plaintiff, because he'd fallen off during exercises prior, had also caused the collision that the trial was
And under what legal theory and case were you objecting to that information coming in?
Your Honor, the legal theory would be that basically under 403, that offering evidence of a prior argument.
Is that, you made a 403 objection that it was, its prejudice substantially outweighed any probative value?
I'll move to that part.
Let me be clear about this, as he's asking this question.
Yes.
Are you, if he's asking about the opening versus the closing, now, obviously, the record reflects that there were objections to the closing, if I recall correctly.
There were, and
But not to the opening.
there was no objection made to the opening, that's correct. the main point of appellant's appeal in this matter is when we were determining what deposition excerpts we could read to the jury. Again, because the appellant plaintiff wasn't there, we had to take his discovery deposition and read excerpts of it. And there is a part from page 42 of his deposition transcript where he is describing going to motorcycle safety training, and during some low-speed maneuvering in a parking lot, he fell off his motorcycle. And that's where I objected in that moment. And this is from page 189, 188, 189 of the trial transcript. The court is saying, now, I don't know what Mr. Coulter is going to argue. That's my colleague. Both of us were trial counsel, which is cool that we're both here now on the appeal. And I was telling the court, we got the telegraph what the defense is going to argue in their opening. In the opening, he said, just like this accident, and I don't want them to be able to repeat that. We go on page 189, the court is instructing me and the appellant, you're gonna need to make a contemporaneous objection. And that's why I said, Your Honor, that's what I'm doing right now, is I'm objecting to this being read to the jury. And the court said, well, and this is on page 190, again, the trial transcript, line 9, I said, at this time, before we offer this excerpt, is me making the objection. And the court later on in that same page says, you can't object because I've already ruled on it. So she admitted over appellant's contemporaneous objection testimony that was far more prejudicial than could ever be probative. What they wanted to do was show that he caused the accident or thereabout for the trial by saying he'd had a prior fall. The court, in sort of a nuanced way, said, well, I bet that what the defense is really going to say is that it was a pre-existing injury, and they're entitled to talk about pre-existing injuries. And on page 191,
Oh, I see what you're saying, Ms. Bowl. Your concern is that you feel like bringing in that prior thing has nothing to do with the right to show he may have had injuries instead of the ones he said he got from this accident, but they could be from the others. Your concern is it showed his aptitude on a motorcycle, and you feel made the jury tend to believe that maybe he had accidents on the motorcycle, and this, in fact, case here was an accident that he caused as opposed to somebody hitting him. Is that your concern?
that's hitting the nail on the head. It would be the same thing as if we were in trial and there was a defendant who had a long history of hitting people in her car or his car, and I said, I want to talk about their driving history in order to prove they were negligent in the collision we're here about today. That's a huge no-no. I would never even try to do that, but that's exactly what they did. And I even said, listen, we can go line by line, and he describes his pre-existing headaches separately from what caused the headaches. So it would be very easy to remove the prior alleged negligence, the prior act, if you will, from the testimony, and it would free the defense to argue, listen, if you're inclined to agree.
And did you let the court know that you had no problem under the rules of evidence letting in that he had had a prior motorcycle accident and maybe had some injuries that you contend had nothing to do with this one, but as long as they don't get into the details of how it occurred?
I let the court know that we could easily bring in his testimony about the headaches and the prior injuries, and we did, and we could easily parse that out from him falling off of his motorcycle prior, which again would be the only evidence that the defense has for the comparative negligence argument, because they had no witnesses, they offered no case.
I think, and correct me if I'm wrong, to me, part of the argument was there even a John Doe driver?
That happened, yes, ma'am.
And so, I mean, to me, that would sort of go to comparative negligence if it was a jury question, whether he just flipped over the handlebars of his own bike or whether he indeed was rear-ended. I mean, wasn't that part of the jury's determination?
I do remember that being part of the defense was that, listen, there either wasn't a car, or if there was a car, it didn't even make contact with him. And the reason you may consider that is because we know he already fell off his motorcycle before.
But wasn't the real problem, Mr. Bowles, that the lady who says she saw the whole thing maybe didn't see the whole thing, or at least the jury could have believed that? I mean, the coworker testified she was right there, she saw it, she described going in the road to scrape him up out of the road, basically. That wasn't a very good way to describe it, but that he needed to be helped. Whereas her daughter said, no, she was behind the counter when it happened. And also, he said, I think in his deposition, I kind of shook it off and got up. So there were a lot of inconsistencies in the testimonies here. That is kind of,
I always say
where
that's
I
like
am.
the Gospels, right? That's how you know they're telling the truth, because they all tell you the main points you need to know, but there are differences.
that's a good argument
And if
for a jury.
I did actually make that exact argument during this case. If the prejudicial evidence that we have objected to and appealed over, if this evidence had not come in and the jury had simply said, we do not find the witnesses to be credible, we're going to render a defense verdict, I don't think we'd have grounds for an appeal.
Right.
But I think this is what tips the scale in the defense's favor, is to say, look at all the inconsistencies and keep in mind he is a new rider, as they argue that a lot, and he's already fallen off his bike before. Isn't it logical to just connect that he did it again this time? If we just taken off that first part about the before, that's just a defense verdict, that's just a credibility of the witnesses issue, not really grounds for appeal. But it's that prejudice of the prior allegedly negligent act that we've appealed about today. And I see I'm about out of my time, so I appreciate y'all listening and inviting us up to talk about this.
Oh, we're happy to have you, and we will hear you in reply.
Yes, thank you.
All right, counsel?
Thank you. Good morning.
See you.
May it please the court, my name is Mike Coulter for the respondent. It's never very easy to defend John Doe at all. And very often I'm in a situation when I do, and I've had to do this many times, I just have to accept, for the most part, what's been presented by plaintiff's counsel and plaintiff's, the witness, that this is how it happened. And as we went through discovery in this case, it became very clear, at least to me, that there were alternative arguments that could be made as to how the accident happened and how the injuries alleged could have occurred. And I certainly don't believe that there's any argument that would be made that presenting something, an alternative to what's being presented by the plaintiff, would be improper, and I don't think it was improper here.
I don't think presenting the alternative or, allowing the facilitation of the witnesses that conflicted, even in their directs, and then your ability to cross-examine them is fine, as is getting in the pre-existing condition. But isn't it a little bit too far to talk about the prior accident was his fault because he was a poor, inexperienced driver in that context? How is that admissible?
Well, I understand what you're saying. In the thing that I think Judge Jefferson, in her analysis of this during our hearing and during the trial, made was I don't think you can separate the two, quite frankly. You have a situation where you have a gentleman training on this bike, had this fall, and if you look at the deposition transcript, we didn't elicit that testimony.
Oh, no, he just volunteered it, it seemed.
He did. And one of the proffers made by plaintiff's counsel at some point said, well, we can just forget about how it happened. Let's just say he had a fall, which concerned me because that's creating fiction out of facts. We have facts. And it's the issue here was a prior head injury, which he himself said was a concussion, which on top of what he claimed was a concussion 6 weeks later, had to do with all these headaches that he had following. And so what I would say is, it's like saying, okay, it's just a head injury. A head injury can be anything. I could be walking down the street.
Mr. Coulter, please.
Yes, sir.
If you would, sir.
Yes, sir.
If it could be clear for me anyway, was your purpose to show that his injuries that he may have had was a result of a prior incident, or was your thoughts to show that he must be lying about this incident because he's already fallen one time?
No, sir.
No, sir, which?
No, sir. My point of the first one was the fact that he had an injury that he brought up, that he admitted, that he said contributed to the injury he claims sustained in the second.
So you had no desire to let the jury know he had a use of a motorcycle on his own that it had a fall, which is what really you were hinting at occurred here, because you said John Doe. I'm sure you wanted the jury, and they may have found there was no John Doe.
That's right.
And you were arguing here that this could very well be just him having an accident, sadly, but that it wasn't the fault of an uninsured motorist.
Certainly, and so
So did you use that for that purpose?
I would say that, well, what would happen is there are certain pieces of evidence that juries can infer many different things from. I don't think, I mean, certainly is that one thing they could have inferred, that he was poor?
Was that one of the purposes why you wanted in there, to give them right to infer from it?
Well, the main purpose was the pre-existing issue, and that had to do with the plaintiff's claims about punitive damages. But to say, it'd be disingenuous for me to say that that wouldn't be something a jury could consider, because that's exactly what was talked about during the incident in itself. And by the way, this issue about having operator error.
Why is that relevant? Not 4-3, just relevant. Why is it relevant, the fact that he had an accident on a motorcycle, a year before, months before?
6 weeks.
Couple weeks.
Yeah,
Only
a month and a half before.
It was 6 weeks. And why was that important? Because he said, again, we didn't elicit this testimony under oath in his deposition, was because that concussion he sustained. And again, this is following.
No, I'm asking you, why is it relevant as to how this accident occurred? Not to his injuries, but how this accident occurred, the one we dealt with in trial here. Why is the fact he had an accident 6 weeks before, why is that relevant to the cause of this accident?
Sure, Judge, and if that is the only issue, and that is I presented that because that was the only issue, I can see that issue, okay?
You concede it wasn't relevant?
Excuse me?
You concede it wasn't relevant?
The fact that he had a motorcycle accident and fell off with a helmet on and hit his head, no, I don't say that's irrelevant.
As to causation of this one?
As to the causation, I would say that operator error was a potential issue here, which is what he admitted happened 6 weeks earlier. So to that extent, yeah, I do believe it is. Okay? But it was primarily presented for the issue of his headaches.
Well, primary doesn't make a difference. It was presented for many reasons. It doesn't matter what your major and your minor was. If your major and your minor got in, your minor is just as important as your major.
Sure, and that's what
movie.
goes to the 403 argument, is whether it's too prejudicial, because it certainly is evidence. Now, whether or not it's too prejudicial or not, I think Judge Jefferson did a good job.
But to get to 403, it's got to have some relevance. Remember,
right?
Although relevant, the prejudicial nature substantially outweighs any relevance, probative value.
Agreed.
So therefore, you're saying the fact he had an accident 6 weeks before that was due to his inexperience, whatever else, or improper handling or whatever, that is relevant as to what caused this accident this day that you're dealing with in court.
What I'm trying to say, Judge, is that was part of the position that you could take. But again, I put it forward, and it had been discussed dozens of times before this case ever came to trial, that this was a pre-existing condition. We were attempting, because in my experience, because
you keep going back to that. I'm beyond that. I'm not worried about the pre-existing condition part.
Okay.
You obviously have a right to put pre-existing conditions in.
Okay.
My concern is trying to legally, how do you do that? And because the judge denied the JNOV for liability when you had two witnesses that said they saw a car. Now, they were different in how things happened, but they saw a car hit him, or they saw a car involved with this accident. Two of them. Now, they were different about how the car disappeared, where the car came from, where the witness was standing, one of the witnesses was standing, and all that. But you did have two people say that this act was caused by a vehicle interacting with him.
Absolutely understand that that's what they said, Judge. And I will tell you that in the course of discovery, it became, at least in my opinion, I understand biased, but it appeared that credibility was an issue there. They had long-standing history with the decedent. They liked the guy. I understand that. But their line of sight, they were looking at something perpendicular to something going by them. One of them that was far closer than the other said it was impossible to see if contact was made. She made assumptions.
And one of them said that the mother wasn't standing where she said she was standing,
No.
even though they were both his witnesses. The credibility issues were pretty big here, it seemed.
Absolutely.
And Mr. Coder, I agree credibility was a major thing with the witnesses, but they were direct evidence testimony. And why is it not wrong to portray this of you using conjecture to counter this direct conflicting evidence?
Well, the big thing, I would say, Judge, is
Being
that,
rough on you, Mr. Calder.
But he's smiling like the Cheshire Cat while he does it.
I would say one of the things I point to very strongly, and this is really why this whole thing came up, the plaintiff himself said he didn't know. He did not know that he got hit by a car. He didn't know. He didn't see a car behind him. He didn't hear a car behind him. He had no idea. He thought his motorcycle had seized up. That was the alternative argument we made to the jury, which whether they believed it or not, I guess they did. But mind you, this wasn't an issue where it was 1% John Doe, 99% defendant or plaintiff. It was no negligence on the part of John Doe. Credibility obviously was questioned by the jury. The mother's...
No, they found there was no John Doe.
That's exactly right. But that's what the witnesses were saying that there was. They decided there wasn't. And the mother, and listen, the mother herself, to her credit, as to the plaintiff's decedent's credit, admitted these things. And I asked the mother herself, are you telling me your son told you that he got hit by a car? And she said, obviously this occurred after the accident. He had his doubts.
I thought the mother and the decedent after this were very forthcoming. The problem was the witnesses who I think wanted to help him ended up perhaps being a tad confused.
I don't disagree with that. And if the mother herself says that her son had doubts, how can a jury not have doubts when it's their burden?
And by the way, one last thing,
Yes,
the
sir.
comment about no objection on the opening statement. Of course, the opening statement, the judge tells the jury that's not evidence. So you feel like him not objecting to the opening statement allowed evidence in, or was it a statement and he probably should have objected, but then again, if it's not evidence, the jury's not supposed to consider it one way or the other, right?
Yeah, I understand that, Judge, and I would tell you that in looking back, I did look back on that. Opening statements, sorry, they're kind of off the cuff. I don't tend to do outlines and read directly from them. I typically don't get into pre-existing condition during opening statements and things like that. But every time I talked about that prior incident, it was always with the qualification that it was about a prior injury. That's what the record reflects. That's how it was presented. That's how I wanted to present it the whole time. And it was clear, we'd had these discussions many times before. This wasn't a surprise at trial at all.
Thank you, sir.
Thank you, Judge.
All right, Mr. Bowles on reply.
Thank you, Your Honor. Again, may it please the court. So the defense, the respondent in this case, is telling the court that the only reason that they offered that evidence was for injuries. And I'll quote from page 284 of the trial transcript in closing arguments, paraphrasing this, from the respondent. You all heard it from the deposition, and I'm drawing the facts from my memory as well. He, appellant, was making a turning and braking motion, and he fell from the bike and hit his head, okay? 6 weeks before this accident, which resulted in headaches as well. So that's a damage that you need to consider as to how that happened and the headache itself. So what he's pointing at is the appellant plaintiff's ability to operate a motorcycle and pointing at him in a prior incident as proof of negligence in the incident that the trial was about. And that is so prejudicial as compared to any possible helpful or probative value as to warrant exclusion.
And did you raise an objection to that at the time? There's
In
an
the-
objection prior to that where there's a similar statement, I think, that's made, but not at that time.
I did not object during the closing argument at that point, no, sir, Your Honor.
Did you object that part of the deposition from the plaintiff coming in?
Over and over again.
But that was from the plaintiff himself.
Okay, I misunderstood your question. When we were sitting in the conference room doing the deposition, Mr. Coy,
Usually you don't object there unless.
I don't
it's
object to
from
my
the
own
question.
client talking.
Right.
But I think you objected to the excerpt coming in.
Repeatedly and kept saying, listen, we can get the injuries in, we can get the headaches in without involving this prior alleged negligence, because as was repeatedly shown in the trial, the defense respondent argued that was proof that there was never a John Doe. It argued that was proof that he just had a malfunction during the incident that the trial was about. And this whole injuries thing was supplied by the trial court. That argument had never come up before until the trial court said, Mr. Coulter, I bet.
Did the plaintiff in the deposition, when he brought up the issue of the prior accident, was that through direct examination, or did someone ask him about it?
It came out of direct examination where defense counsel,
Well, if he brought it in himself, how do you keep it out if defense counsel didn't bring it in, the plaintiff brought it in himself?
my clients say all kinds of things at their deposition that doesn't mean that it can be talked about at trial. I mean, they talk about family reunions or any other number of things. When we're talking at that moment for a discovery deposition, my impression was he was trying to explain to defense counsel his headaches. And he was just,
Well, he volunteered.
He was in
I'm looking at the excerpt. The question was, do you care, after we get through taking your deposition, do you mind me taking a photograph of your scar? And then he said, sure, sure, sure. And then he went into his soliloquy, basically, about the prior accident and the
all
concussions.
of his answers were like that. He loved to talk. I got to know Daniel before he passed pretty well because we both ride motorcycles, and he's just like that. So if I showed you his deposition transcript, it was thicker than it had to be because all of his answers.
Oh, we have a lot of it. So.
And but
He
that,
was very forthcoming. It really was.
his talkative nature still does not mean that that information can be revealed to the jury. Again, because of the harm that it causes, and again because it's completely unnecessary.
Being a former small town, and I know you're a large town, you're North Charleston, but being a small
No,
town.
he's James Island councilman, right?
Sometimes, yeah.
Yeah, well, but being from Dillon and having a couple of cases as a plaintiff, in fact, he was on the other side of a couple of them.
I am caught in between them. It's like an old married
Why
couple.
could y'all, on $1,000 worth of damage, y'all couldn't settle them out? My goodness.
No, we couldn't. You know, I mean, if you know from the plaintiff side, your different insurers look at damages differently, and I don't have a good track record with that one. So we were not, getting there. I just want to close by saying again, if they hadn't let that part in about the prior allegedly negligent act, I wouldn't have appealed this case. We wouldn't be here right now. It would just be a question of believability. But it was argued over and over and over, and it definitely put a finger on the scale as far as the jury was concerned, in my opinion. I appreciate, again, on behalf of Mr. Coy and his family, y'all hearing us and having us up here today.
Well, it's good to see both of y'all. Thank you for your fine arguments. Normally, we would come down and shake hands, but there are a lot of bugs going around right now, so I'm just going to wave and wish y'all a safe drive home in your opposite directions of the state. Thank you so much.
Be upstanding for the court.
And we will be adjourned for a few minutes till our next argument. Thank you. Good to see both of y'all.
You all too, have a good day.
Did you ride your motorcycle down here from the local?
No, sir.
I-26
That's
will
not
be
my hair
no
when I wear
fun.
a helmet all the way up.